Thanks, Ben. Hi, everyone. My name is Carly Nyst. I'm the legal director at Privacy International. PI is an organisation that has been around for about 25 years next year, working to promote the right to privacy around the world and fight against unlawful surveillance. I'm going to talk today a bit about the cases that we've brought in the past 18 months since the Snowden revelations first began. PI sees litigation as a tool to achieving legal, political and social change. So when we first found out about the Snowden revelations, although many of the practices and processes revealed by some of the Snowden documents were already known, obviously, to many people in this community, including people like Duncan Campbell here today, who's been investigating things like this for many years. Of course, what Snowden gave us for the first time was the tangible evidence that we needed to begin to litigate some of these allegations. And when we sat down with the Snowden documents and everything that has been revealed since summer 2013, we tried to kind of really focus in on what we saw as some major flaws in domestic legal frameworks that were enabling the surveillance activities that are being perpetrated under the guise of legality. So we looked at some of the legal frameworks that Ben canvassed and tried to pick out the features of those frameworks which were allowing mass surveillance by the Five Eyes intelligence agencies. So, and Ben touched on many of these, but one of them is, of course, the mass nature of surveillance and the legislation which enables untargeted or suspicionless surveillance to take place under the guise of foreign intelligence gathering. So that was a feature of many legal frameworks that we identified that we needed to change. Just as an aside, as Ben rightly pointed out, most countries have two sets of legal frameworks which deal with targeted surveillance for law enforcement means, which is regulated in a particular way, and then untargeted intelligence gathering, mostly directed at foreign targets, which has a much lower level threshold and much looser legal safeguards. So we really looked at those legal frameworks. The second characteristic of the legal frameworks we identified was the discriminatory nature of them. That is, that they afforded higher protections to nationals or citizens than they did to non-nationals or those abroad. So we're looking at that in a discrimination sense. And then the third was around intelligence sharing. And I think one of the really landmark things we have learned from Snowden that wasn't so evident previously was the highly integrated nature of intelligence sharing in the digital era and how automated it is, how highly elevated it is, and how constant and mass it is. Again, many investigative journalists and other researchers had been writing for years about relationships between the US and the UK, but what we were able to derive from the Snowden documents was the kind of total disclosure of intelligence material between the Five Eyes countries. Every single one of those Snowden slides, you'll notice, has a little statement at the top which says release to Five Eyes agencies, which means that every one of those Snowden slides were being shared, or most of them anyway, were being shared as a matter of course with all the Five Eyes partners. And we've learned other things, for example, that in Menwith Hill there are 250 NSA agents and 300 GCHQ agents, and they act together in certain intelligence operations, that some intelligence analysts have badges that let them into buildings in both the US and the UK, and that there is generally a very high level of intelligence sharing going on between the agencies. So we identified mass surveillance, discrimination and intelligence sharing as three legal challenges that we wanted to go after in litigation. And we've now taken in the past 18 months 4 pieces of litigation. And so I'm going to talk about those 4 and a fifth that we yet would like to bring. So starting with the simplest one, we decided we were going to try and get copies of the Five Eyes agreement when we first started doing our research. And the Five Eyes Agreement was originally signed in 1946, and it wasn't declassified until 2010 when parts of it were published by the National Archives and are available online. But that original 1946 agreement is only the first of many, many documents that came afterwards, addendums and annexes, etc., none of which are available to the public, yet all of which detail and deal with the rights of all of British citizens and Five Eyes residents in a great amount of detail. So we felt very strongly that those documents should be public, given that they affect our rights so significantly. So we sent freedom of information requests to all Five Eyes governments. We were knocked back by every single country. We appealed in internal appeal mechanisms. We were knocked back again in every single country. And so we decided to appeal the blanket exemption that GCHQ enjoys here in the UK. That is, you can't send a freedom of information request to GCHQ, as many of you journalists will know, because they have a blanket exemption from freedom of information laws. We decided to try one more time. We wrote to them again, we asked for the Five Eyes agreement, and we also asked for a list of other things, including the menu on the cafeteria at GCHQ, in order to illustrate how arbitrary a blanket exemption to freedom of information is. And of course, we were knocked back again. So we've now we've now made an application to the European Court of Human Rights under Article 10, which is the right to freedom of expression, but also to access information. I imagine now won't hear anything from them for about 5 years, but in any event, we thought it was a kind of cheeky way at getting at this blanket exemption, which we say acts as a kind of smokescreen to insulate the intelligence agencies from any type of scrutiny. So that was one way of getting at the intelligence sharing aspect of the laws. The second case we brought was against the British Intelligence Services in the Investigatory Powers Tribunal here in the UK. And we brought a case saying that, with two major allegations. One, that their access to US intelligence, particularly in the PRISM program, because we filed this, I think, 2 weeks after the first Snowden revelation, so our knowledge was still at the very early stages. We said UK access to PRISM is a violation of Privacy International's Article 8 and Article 10 rights. And we also said that the UK Tempora program, the mass surveillance program being run here, is a violation of Article 8 and Article 10, so privacy and free expression. We were joined in that case by Liberty and by Amnesty International. We were also joined by a number of international organisations. So we work with a digital rights organisation in Pakistan called Bytes for All, and Bytes for All also filed here in the UK, as did the ACLU from the US, a South African NGO, an Irish NGO, etc. Together we wanted to illustrate not only that the mass surveillance and the mass intelligence sharing activities are unlawful, but also the discriminatory nature of the UK legal framework, which provides higher protections for British residents, is unlawful. So strategically we brought in international organisations who could make that argument strongly. We spent the last year and a half in court in various legal submissions, and we had a week-long trial over the summer. Then there was a closed hearing that we weren't allowed to attend, where the intelligence services made further submissions, and we got our decision on Friday, and as many of you will have heard, we lost, unsurprisingly. The court ruled that mass surveillance, in theory, because they only considered our hypothetical allegations, they didn't require the government to make any admissions about the accuracy of our allegations. They said, in theory, mass surveillance in the form of tempora, that is the bulk interception of all communications in and out of the UK, and the storage of content for 3 days and of metadata for 30 days. In theory, that is lawful under British law and is not a contravention of the rights to privacy or free expression. They said that the provisions that allow for British residents to have a higher degree of privacy protections are not discriminatory against non-British persons. They said that the discrimination is not unlawful. It's a justifiable form of discrimination because to afford foreigners the same level of privacy protections as nationals would drastically impede the ability of the security services to do their work. This is kind of verbatim from the judgment. Finally, on access to PRISM and US intelligence material, they said that it's true that there wasn't very much information in the public domain prior to our case on what the processes are in place for UK access to intelligence material. But because the government so kindly has divulged some information reluctantly throughout the litigation, the court says actually now it is lawful because they have made numerous admissions throughout the litigation process as to how they do intelligence sharing. They actually also pointed to some of the material that's now in the public domain, including published material by The Guardian, to say that, well, now everybody knows about this process. It is in the public domain. It's clear to the British people what's going on. Therefore, it's lawful. So we've brought a separate application now asking them to declare that everything prior to yesterday was unlawful, because if they say that the judgment or the court case made the activities lawful, then there must have been a time in the past when they were unlawful. We expect, again, they won't grant that, but that's our kind of last hope to win something out of this court case. In any event, we'll certainly be applying soon to the European Court of Human Rights to review those decisions. And the court is also looking at the proportionality of the interceptions, although they've declined to look at the proportionality of tempora as a whole, and will only look at whether or not Privacy International had our communications intercepted and whether that was a proportional use of those powers. So inevitably it will be an unsatisfactory judgment, I think, in the end. But that's something to kind of look forward to. I think when the European Court gets its hands on these cases, we're very hopeful that they will see things differently. There are, of course, a number of other cases pending in the European Court, which I think Gavin will speak about as well. And quite likely we're going to get some type of super giant case before the ECHR in the coming years. And we have kind of big hopes that they'll make the right decision. I realise I've spoken too long already, but just to go quickly onto the other cases that we've brought. We've also, arising out of the Snowden revelations, we've brought 2 cases against the UK government's use of computer network exploitation and hacking methods, particularly related to the leak in respect of GCHQ hacking Belgacom, which has been obviously in recent weeks validated by the revelations around the Reagan malware. And we brought this case now a year ago, but those more recent documents will certainly feed into it. We brought a case on behalf of Privacy International, but we also worked with 7 ISPs and computer infrastructure providers, including the CCC, RiseUp, May 1st People's Link, GreenNet, GreenHost, MangoNet, and Jinbonet. And all of those companies together brought a case against GCHQ. So we've got those 2 cases which have been rolled into one. They got stayed pending the finalisation of the case that we received our judgment on Friday. So we've already received a letter from the court saying, okay, we're ready to go ahead with the hacking cases. So that will happen in the first part of next year. And there we've argued that the use by the government of hacking tools, both on a mass scale, but even in and of itself, given that it is not legislated in the UK at all, is a violation of Articles 8 and Article 10. The 4th case that we brought, which is less of a case but more of again a cheeky legal manoeuvre, is to bring a case against some of the telcos who were revealed to be collaborating with GCHQ and providing access to undersea fibre optic cables. We brought a legal challenge under the OECD guidelines for multinational enterprises. So this is a voluntary set of guidelines which the UK is a signatory to. And as part of being a signatory to the OECD guidelines, they have to establish what's called a domestic national contact point, which is an office that lives within Department of Business, Innovation and Skills, which is supposed to monitor companies' compliance with these guidelines. So we made a complaint to the national contact point saying Vodafone, BT and others, all of whom were named in a number of Snowden documents for providing direct access to cables in compliance with British warrants, that those companies were in violation of their own human rights obligations to push back against government infringements on human rights and to, as much as possible, facilitate the human rights of their users. So we brought a complaint to the national contact point, and surprise, surprise, the national contact point rejected our complaint just recently, saying, among other things, that the Snowden documents were not verifiable, which we thought was quite audacious, given that there has been very genuine acceptance of their veracity even by members of the US government, although, of course, not by any members of the UK government. But moreover, it seems to be their impression that, or their feeling that, given that the actions of GCHQ are lawful and given Friday's decision, there's even more of a kind of cover for them in saying that, I suppose. Given that any warrants issued to telcos are lawful under British law, there's no separate obligation on telecommunications companies to push back against those warrants, to challenge them in court. We disagree with that as a finding, of course, but we're a little bit stumped now about where to go next, to be honest. It's quite hard to establish the legal obligations of companies with regards to human rights. It's a kind of burgeoning area of human rights law, and there's not a lot tangible to grab onto to say that companies have human rights obligations that aren't trumped by their legal obligations as decided by the state in which they operate. So that's something that we're kind of thinking about still going forward. The last thing I'll say is the case that we would like to bring but haven't yet brought is a Fourth Amendment challenge in the US. And I'm interested to pick Kerry's brain on this. We think that the US organisations are doing a fantastic job to challenge the activities of the NSA, but most of it has been in relation to the rights of Americans. And one of the real problems that we can see with FISA and the American laws is that it offers severely lower protections for non-Americans. And we think that that should be considered in US courts, and that non-American citizens should have a claim to Fourth Amendment, which protects against unreasonable search and seizure in American courts. Unfortunately, the Supreme Court of the US disagrees with us on that point, and we've not yet found a way in to bring a case there, but we hope it might be something that will happen in 2015. Thanks very much.